We're starting this one at sentencing, and you can feel it immediately. The court already knows this defendant. This is State versus Melissa Hotchkiss, and she's here after pleading guilty to aggravated possession of drugs, F5, and possession of heroin, F5, with a forfeiture specification riding along. Translation: this isn't a "did she do it" moment. This is "what are we doing with her now" moment. And the defense basically admits the problem out loud. This has been a revolving door: drugs, caught; prison, out, caught again. The attorney even says the record makes her look like a terrible candidate for anything except prison, but then pivots to the word that courts hear every day. This time is different. And to give that claim some weight, he brings receipts: a bed secured at Hitchcock Center for women, potentially ready within days. That's not talk. That's at least a plan. But the judge? The judge is not buying slogans. Because the court has heard "I'm ready" before, and the file shows she walked away from opportunities like NEOAP in the past. So here's the hook. Is this a genuine rock-bottom turnaround, or just another chapter in the same cycle?
Case number is 25CR42324. Ms. Clendenin is present with her counsel, Lindsay Arway. The state is represented by Brian Goodyear. We're here for a bond hearing. What's the request?
Thank you very much, Your Honor. Ms. Clendenin, I believe, is actually requesting to have the monitor removed, understanding that that is a pretty lofty request. The basis for that request, Your Honor, is that at this point, I know that she has her main employment with the cheer and tumbling facility. However, she is also working, is it Soiree? Is that how you say it? Soiree Wellness, which is actually LA Tan, and she is up for a promotion with that company into management. As part of that promotion, which she tells me they are looking to officially promote her as of January 1st of 2025, she would be required to have a dress code. I don't know that the dress code's necessarily the biggest issue. I think the biggest issue is that as part of her promotion, she would be required to utilize some of the wellness services so that she's able to appropriately advise customers and clients as to those services, and it has the potential to very much damage the monitor itself. And I know that those are very expensive. I think we had a client who was told that they cost somewhere in the range of $3,000. So as part of testing these products and services that are available through the company, which is required as a management position, it has the potential and likelihood almost to, in fact, damage the device itself. I was also provided, if Your Honor would like to take a look at it, with a copy of the company policy on management guidelines and dress code from Ms. Clendenin, which notes that it is their official policy, and it does have their Soiree Wellness LA Tan information on it for Your Honor to take a look at, that represents that this is something that is required for the position. I know that in the event that Your Honor is not inclined to grant the removal, that Ms. Clendenin also is looking to have, perhaps if Your Honor would consider open hours. It's my understanding that, LA Tan and the wellness company as a whole, they're Saturdays, they're Sundays, so they're open 7 days a week. And as part of her management position, she would be required to go in the event that an employee calls off. It would fall on her shoulders in order to be the one that actually goes in. And I believe at this point it would be difficult if that were to be during hours when the court or probation or pretrial are not open for her to be able to get permission in order to do that. So I think that I've covered the gist of what we're asking for, correct? The hours as well as the
dress code,
okay.
the services, yes.
And again, Your Honor, I do have that form here with the rules and regulations if you would like to take a look at that.
Oh, just a moment. Anything from the state?
Your Honor, this is like deja vu all over again. Ms. Clendenin was almost exactly this many days from the last jury trial setting when she asked this court to remove her monitor at that time. The court had a chance to consider that request, denied that request, and then shortly thereafter, Ms. Clendenin fired her attorney, from my perspective, for reasons that I still don't understand. I know for a fact, in speaking with him at the time, that Ms. Clendenin never even spoke with him about it. She never gave him any reasons. There was never any problems, any concerns. He just found out she had a new attorney. So, I just bring this back initially to the fact that she's charged with attempted murder, and she nearly killed someone. And she confessed to the fact that she nearly killed someone. And luckily for her, she had people with resources sufficient to secure her release from jail. And I understand that, as the motion mentions, she's not tested positive for any drugs during the time she's been out. However, having said that, the state's main concern is her appearance at trial. The fact that she tried to get off the monitor 30 days before trial the last time, it was denied. She finds a way to continue the trial. Now here we are once again, the same period of time before trial, asking again. It just is very concerning to the state that what really is happening is she's trying to get a 30-day head start. She knows, I'm sure, like everyone else knows, if you cut that monitor off, they know immediately it's done, and they'll come out and they'll try and arrest you immediately. Judge, this is just such an odd conversation to have. I'm about to be a manager on January 1st, but I'm going to trial on January 26th in a case where, Judge, even if she's only convicted of improperly discharge of a firearm into a habitation, if that's the only conviction she receives, to which she confessed, she faces a minimum of 10 years in prison. Minimum of 10 years in prison. So she has a massive incentive to run, to not appear for trial. And frankly, it makes this thinking, this motion, to me, almost nonsensical. You're going to be a manager for 25 days, and then you're facing a minimum of, best case scenario, probably, with the charges that exist, 10 years in prison. So I think that, Judges, the state's perspective that the overall situation here is very concerning. We would ask you to deny both the requests. She's facing serious prison time on serious charges, and I think she's been given a lot of leeway up until this point considering those factors. So the state would ask you to deny both. Judge, the victim's mother is present. She would like to address the court as well.
Okay.
Would you like for us to step to the
No,
side?
she can just use the table there. Do you have any paperwork that you're
No,
working?
not at all. Not at all. Let
Okay.
me just move this out of the way here.
Yeah, that red light's what's important, ma'am. It's the microphone.
Okay.
Go ahead.
I just wanted to speak on behalf of my son. I heard what this was about today, and I think it's absolutely absurd that she's requesting this when my son can't even hold a job down since this happened because of the injuries that he's sustained, the stress that he's gone through, the mental anguish that he's experiencing because of her actions, and that she has the audacity to come in here and ask for this to happen before the trial because she would like a management position with a job that she's holding right now. It just makes no sense to me whatsoever, Your Honor, when my son, because of her actions,
When defense counsel openly calls it a revolving door, that's strategic honesty, and it's also an alarm bell. Judges respect candor, but they don't ignore patterns. The attorney is basically saying, "Yes, Your Honor, the record screams prison, but please consider treatment anyway." And then he frames the case around rock bottom, not as an excuse, but as a turning point. Legally, this matters because sentencing isn't just punishment, it's also risk management. The court has to decide whether community control can realistically protect the public and help the defendant stop reoffending. And the bet at Hitchcock is the defense's strongest card, a structured residential program, immediate placement, and accountability. That's the kind of alternative to prison courts sometimes consider when addiction is driving the criminal behavior. But here's the audience question. When someone's track record is prison after prison after prison, How many last chances should the system give
I can't
before it
believe that
stops
she's even
believing?
asking that. So that's all I wanted to say.
Okay, well, you said it well. That's a logical statement, understand. So thank you.
Thank you, appreciate it.
Okay.
My name is Misty Johnson. Yes, thank you.
So basically, she's presumed innocent as far as where we are on this. I'd already sort of come to this conclusion before I heard from the victim's mother, but it makes a lot of sense. I mean, when something happens like this, there are consequences. And I don't think she's going to run. I don't believe that. I'm not concerned about that at all.
I would suggest that's not a concern as well, Your Honor.
She's, number one, shown she can comply. I mean, this probably, regardless of the attitudes about it and the understandable attitudes about it, it seems like a very unusual thing given her history, but it happened. And it doesn't make sense to go ahead and make these changes. Here we are 30 days from trial. There were two requests. One was
So one was to remove the monitor, Your Honor,
Yeah,
and the second request was somewhat with the first request in the sense that the management position would also require her to go in and cover, but I would indicate that as a second request, in the event that the monitor is not going to be removed, that perhaps she be granted open hours as it relates to the fact that she's not had any contact with anyone. Your Honor's noted she's demonstrated her ability to appear and her full compliance with everything up to this point. And I think the reason for that is it would at least give her the opportunity to assist in covering things for the company in the event that that's needed, or for her to be able to pick up the additional time.
What time do they close?
9 p.m.
Okay. All right, so the request is denied. I will modify her hours from 6 a.m. till 10 p.m. However, on New Year's Eve, you stay home. You still can't consume alcohol. That's a rule. Anything else from the state?
No, Your Honor.
Anything else, Ms. Arway?
No, Judge. Thank you very much. Your Honor.
New Year's Eve party in Warren County ended in gunfire. One person's in the hospital fighting to recover. Police say it started after a woman became angry over her ex and her boyfriend hanging out. Ken Brown is live outside of the Warren County Jail and the courthouse where he is locked up facing attempted murder charge. Ken?
Yeah, that woman's name is Olivia Clendenin. She's locked up in the jail off screen to my left here, and tomorrow she will face a judge in the courthouse behind me.
Early on New Year's Day, Clear Creek Township Police got a call to this home along Dearth Road for a man shot.
The initial call was the belief that it was a drive-by shooting. When the officers got there, they did find one individual had been shot in the stomach.
Inside the home, a celebration of the new year was happening overnight, but it wasn't until 5 in the morning when the fun ended with gunfire.
It was a New Year's Eve party. There was a girl that was involved with a boyfriend there, and her husband was there. I believe they're in the process of maybe divorcing, but maybe had not completed that yet.
Outlined in Clear Creek Township's police report are witness statements that say Clendenin was not happy with her ex and her boyfriend hanging out together.
There was kind of this three-way argument going on at the party. At one point in time, we understand that she left the party, returned. The argument continued.
Police say that verbal argument turned much more serious when Clendenin left the party a second time.
She had obtained a gun, and when she drove, she actually did a kind of a donut in the front yard, which put the driver's side toward the front of the house. The driveway's on the left-hand side of the house. She did a donut in the front yard, and as she past the front door area, she fired off a couple shots.
One of those hit a man in the stomach. Police say the man hit was not involved in the earlier arguments. He was taken to the hospital and has already undergone one surgery. Police said as of last night, he's expected to survive. After firing the shots, the chief says Clendenin tried to drive off, but that didn't end well either.
Ended up going down the road and crashing out her car, where she sustained some injuries.
Olivia Clendenin is due in the courtroom and the courthouse behind me at 2:30 tomorrow. Jail records indicate she's facing 5 felonies. Police tell us the most serious among them is an attempted murder charge. Reporting live in Lebanon, Ken Brown, Fox 19 Now.
Turned much more serious when Clendenin
aggravated
left
possession
the
of
party
drugs and
a
possession of
second
heroin,
time.
and
She
appeared
had
for
obtained a
sentencing with a
gun,
record that the
and,
defense itself described
when
as
she
a
drove,
revolving
she
door
actually did a
of
kind of
addiction
donut in the
and
front yard,
incarceration.
which put the
The
driver's
state
side
argued
toward the
she was
front of the
not
house.
amenable to community control,
The driver's,
pointing to her prior
the
failure on
driveway's
community
left-hand side
control
house,
and
she
her
did a donut
escape
in the
from
front
NEOAP.
yard.
The judge
And,
pressed hard on
she
credibility,
passed the
readiness,
front door area,
relapse
she fired off a
history,
couple
and
shots.
treatment
One
follow
of
through,
those hit a man
including
in
her
the
decision
stomach.
to
Police
stop
say the man
psychiatric
hit
treatment
was
after
not
relapse.
involved in the
Despite
earlier
clear
arguments. He was
skepticism,
taken to
the court
hospital and has
imposed a
already
structured
undergone one surgery.
rehabilitation-centered
Police
sentence.
said, as
5
of
years
last
community
night,
control,
he's expected
70
to
days jail
survive.
with
After
credit for
firing the
54,
shots, the chief
placement
says
into the
Clendenin
Hitchcock
tried
Center
to
for women
drive
when a
off,
bed
but
becomes
that didn't end
available,
well either.
and strict
Ended up
conditions
going down the
including
road
mental
and
health
crashing
treatment,
out her car,
meetings, sponsorship,
where
controlled
she,
medical access,
she
and
sustained
compliance
some
monitoring.
injuries.
The judge also made the stakes
Olivia
unmistakable,
Clendenin is due in
violate,
the courtroom
and she
and the
faces up to
courthouse
24
behind me
months
at
in prison,
2:30
plus the
tomorrow. Jail
cascade
records
of
indicate she's
post-release
facing
control
5
consequences.
felonies. Please
This
tell us the most
case
serious
is the
among them
courtroom
is an
version
attempted
of a
murder charge.
crossroads.
Reporting
One
live in
path
Lebanon,
is
Ken
recovery
Brown,
with
Fox
structure,
19 Now.
the other is prison with certainty. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.